I own a 2-bedroom chalet at Timberline Village, a 90-unit ski community at the base of Silver Notch Mountain, and for 3 years, our HOA required every owner who wanted to rent their unit to use one specific management company, charging a 40% commission, nearly double the market rate. Co-owned, it turned out, by 2 sitting board members. I found out our state had passed a law 6 months earlier, making that exact mandate illegal, a law the board simply never bothered mentioning to any of us. My name's Nadia Kowalczyk. I'm 52, work remotely as a software consultant, and I bought a 2-bedroom chalet at Timberline Village, a 90-unit ski-in, ski-out community at the base of Silver Notch Mountain, 4 years ago, splitting my time between the unit myself during ski season and renting it out the rest of the year to help offset what turned out to be a considerably larger carrying cost than I'd initially budgeted for. I'd been drawn to Timberline Village specifically because a college friend who'd bought there a decade earlier described it as one of the few resort communities on the mountain where owners genuinely governed their own building, rather than ceding effective control to whichever management company the original developer had installed and never fully released. That reputation, I'd eventually learn, had mostly survived on inertia rather than any particularly vigilant ownership base, since Garrison Voss's 3-year tenure demonstrated plainly how quickly a board could quietly capture that kind of governance, once enough owners treated their vote as a formality rather than an actual responsibility. Timberline Village's original 1998 declaration, like most ski resort HOA declarations, permits short-term rentals as a matter of course, since resort communities like ours depend economically on a healthy rental market, rather than treating short-term guests as an unwelcome exception the way a typical suburban HOA might. What the original declaration never required, and what a board rewrite 3 years ago quietly introduced, was any restriction on which management company an owner could use to actually handle those rentals. The board that made that change was led by a president named Garrison Voss, a part-time resident who'd purchased his own unit, specifically as a rental investment property, rather than for personal use, and who ran, alongside a fellow board member named Priya Deshmukh, a rental management company called Summit Peak Rentals that, until the declaration amendment, had competed for owner's business against 4 or 5 other independent management companies serving the mountain, the same way any resort town typically has multiple property managers competing on service and commission rate. The mandate itself arrived through a declaration amendment, passed at an annual meeting I hadn't attended, buried, as these things often are, under a bland agenda heading describing it only as a rental program standardization update, language vague enough that the amendment passed with barely a quarter of owners voting at all, well under the turnout that might have generated real scrutiny of what the change actually required. Once implemented, every owner wishing to rent their unit short-term was required to list exclusively through Summit Peak Rentals at a standard 40% commission, with the declaration specifying financial penalties, escalating up to a $500 monthly fine for any owner found renting through an independent manager, a booking platform directly, or even word-of-mouth arrangements with returning guests. I'd been using an independent local property manager, a careful, responsive woman named Colette Fournier, who charged an 18% commission, and had managed my unit successfully for its first year of ownership, generating consistently strong reviews and a steady booking calendar I'd been genuinely happy with. The mandate forced me to either switch to Summit Peak Rentals at more than double Colette's commission rate, or face escalating fines that, over a single rental season, would likely exceed what the commission difference itself would have cost me anyway. I called Garrison Voss directly to ask why the board had implemented an exclusive management mandate that more than doubled owners' rental costs without any competitive bidding process to justify the rate. His response was the moment I understood exactly what kind of board Timberline Village had elected. Nadia, Summit Peak provides a consistent, quality-controlled guest experience across the whole property, which protects everyone's property values. A patchwork of different management companies with different standards creates real brand risk for the community. I understand the commission feels high, but you're paying for consistency. I told him a 40% commission was nearly double what every other property manager on the mountain charged for comparable service, and that brand consistency didn't obviously require every single owner to use one specific company his own board seat happened to co-own. Garrison's answer, delivered with the easy confidence of someone who'd clearly never expected serious pushback, was the line I'd repeat to Colette and several neighbors over the following weeks. The board considered several options and determined this was the right structure for the community's long-term interests. I'd encourage you to review the amendment's rationale in the meeting minutes if you have further questions. I didn't have the resources for an immediate lawsuit, so instead of hiring an attorney first, I did some basic research into whether any state law actually addressed exactly this kind of HOA rental management mandate. Research that turned up something Garrison's own board had apparently never bothered mentioning to the ownership at all. The state legislature, 6 months before Timberline Village's amendment even passed, had enacted a Rental Management Freedom Act, specifically prohibiting homeowners associations from requiring owners to use any particular rental management company as a condition of exercising their otherwise permitted right to rent their own property, a law passed in direct response to documented patterns of exactly this kind of board self-dealing at ski and beach resort communities across the state. I brought the statute directly to Garrison at the next board meeting, expecting the mandate to be withdrawn once its plain illegality was pointed out. Instead, Garrison's response, backed by a brief legal memo from the board's own retained attorney, argued that the statute applied only to an owner's right to rent generally, not specifically to the choice of management company. A reading Colette's own attorney, once I retained her for a formal opinion, characterized as a strained interpretation that ignores the statute's plain text, which explicitly names rental management company selection among the protected owner rights the law specifically enumerates. The board, over my continued objection, declined to rescind the mandate, apparently betting that the cost and inconvenience of a legal challenge would deter most individual owners from pursuing the matter further. Colette herself helped me prepare that complaint, having lost roughly a third of her own Timberline client base to the mandate over its first year, and having already, unbeknownst to me at the time, filed a similar complaint of her own on behalf of her broader business interests across 2 other affected resort communities on the mountain, facing comparable mandates from their own boards. Learning that Timberline Village wasn't the only community the new statute needed to reach gave the whole effort a scope considerably larger than my own individual rental dispute, a detail that, once I mentioned it to the division's investigator, seemed to genuinely strengthen the case's priority within her own office's broader enforcement docket. I filed a formal complaint with the state's Real Estate Regulatory Division, which had been given specific enforcement authority under the new statute, attaching the declaration amendment, the fine schedule, and the board attorney's own memo, attempting to narrow the law's scope. The division's investigation, once opened, moved with more institutional weight than my own individual dispute with Garrison ever could have generated alone, and its formal determination, issued 4 months later, rejected the board's narrow reading of the statute entirely, finding Timberline Village's exclusive rental management mandate a direct violation of the Rental Management Freedom Act, and ordering the board to rescind the amendment, refund any fines collected under it, and formally notify the full ownership of both the violation and the correction. The board rescinded the mandate within the 30 days the division's order required, and I switched my own unit back to Colette's management immediately, along with, based on informal conversations at the community's shared gear room over the following weeks, roughly a third of Timberline Village's other rental active owners, who'd been quietly waiting to see how the dispute resolved before making their own move away from Summit Peak Rentals. I thought, once the mandate was formally rescinded and fines refunded, that Timberline Village's rental management dispute was fully resolved. I was wrong about that, in a way that revealed the 40% commission mandate had been generating considerably more than just excessive fees for Garrison Voss and Priya Deshmukh personally. Colette, helping me review my own account statements once I'd switched back to her management, mentioned almost in passing that she'd heard from another manager on the mountain that Summit Peak Rentals had been unusually generous with referral payments to a handful of local vendors over the preceding 3 years, a detail that struck her as odd given how thin resort property management margins typically run even at a 40% commission rate. That comment sent me back to the State Real Estate Division's own complaint file, where a records request turned up something the division's rental management investigation hadn't specifically been scoped to examine. Summit Peak Rental's own corporate filings showed a vendor consulting payment arrangement with a third board member, a woman named Ilsa Fenwick, who chaired Timberline Village's separate amenities committee. Payments that, once I compared them against board meeting dates, correlated closely with several key votes Ilsa had cast, supporting the original rental mandate amendment. Retaining a forensic accountant, a methodical woman named Beatrix Solano, to review Summit Peak Rental's full financial relationship with Timberline Village's board members, confirmed what Colette's offhand comment had first suggested. Ilsa Fenwick had received $67,000 in consulting payments from Summit Peak Rentals over the 3 years the mandate was in effect. Payments Beatrix's review found had no corresponding deliverable or documented consulting work product of any kind. Structured, in her professional assessment, to function as a straightforward vote-buying arrangement, rather than any legitimate business relationship. Ilsa Fenwick's attorney, once confronted with Beatrix's findings, initially characterized the payments as legitimate compensation for informal market research and vendor coordination Ilsa had performed for Summit Peak Rentals, independent of her board role, a defense that began to unravel once Beatrix's review turned up text messages, produced during the State Division's own follow-up investigation once I forwarded Beatrix's findings to them, in which Garrison Voss explicitly referenced needing Ilsa's reliable vote on the rental mandate amendment in the same conversation thread discussing the timing of her next consulting payment. Timberline Village's ownership, once these findings became public at a community meeting Beatrix and I presented jointly, organized a petition under the state's HOA governance statute to remove all 3 implicated board members, Garrison, Priya, and Ilsa, through the same kind of expedited, targeted removal process available for documented breach of fiduciary duty that other communities facing similar board self-dealing had successfully used, gathering well beyond the required signature threshold within 3 weeks, given how directly the vote-buying evidence spoke for itself, once laid out plainly. All 3 board members were removed at a special meeting by an overwhelming vote, and the reconstituted board, working with Beatrix and our attorney, pursued a civil recovery action against Summit Peak Rentals, Garrison, Priya, and Ilsa jointly, ultimately settling for $310,000 in combined restitution, covering both Ilsa's improper payments and a portion of the excess commissions the mandate had extracted from owners during its 3-year run. While the reconstituted board's recovery action against Garrison's group was still working through settlement negotiations, our new interim board president, a longtime full-time resident named Otto Reinhold, discovered something in Timberline Village's correspondence file that suggested the rental management scheme had never been operating in isolation from the resort's own broader commercial interests. Silver Notch Resort Group, the company operating the mountain's ski lifts and base village commercial space, had proposed, in a letter addressed to Garrison during his final months as board president, a licensing arrangement under which Timberline Village's HOA-owned recreational amenities, the community pool, hot tub facility, ski equipment storage room, and shuttle service, all guaranteed as free-of-charge owner benefits under the original 1998 declaration, would be leased to Silver Notch Resort Group's own guest services division, converting free owner access into a paid amenity package the resort would then market and sell to hotel guests and Timberline owners alike, on the resort's own pricing schedule. Otto brought the proposed amenities licensing arrangement to the full ownership at the next community meeting, and it became immediately clear that Garrison, in his final weeks as board president before his removal, had been actively negotiating terms with Silver Notch Resort Group without ever disclosing the proposal to the broader ownership, a pattern of concealment that, once combined with everything else the community had already learned about his tenure, generated a level of collective owner scrutiny considerably sharper than the original rental mandate had ever received. Otto Reinhold had lived at Timberline Village year-round for nearly 15 years, one of a small handful of full-time residents, among a membership mostly composed of part-time owners and investors. And he told me once, over coffee at the community's own small cafe, that full-time residents like himself often noticed governance problems earliest, simply because they were the ones actually present at the pool, the gear room, and the shuttle stop, often enough to see exactly how a proposed change would land in daily practice, rather than just on paper. I helped Otto organize what became the Timberline Owners Coalition, formed specifically to review and, if necessary, formally oppose the proposed amenities arrangement, since any lease or license of HOA common property required, under the original 1998 Declaration's own amendment provisions, a two-thirds ownership vote, given that it involved a material change to guaranteed owner benefits rather than routine administrative business. Silver Notch Resort Group. Once the proposal became public and the coalition began organizing opposition, mounted its own campaign emphasizing the arrangement's promised benefits, expanded pool hours, professional staffing, and integration with the resort's broader guest services app, while notably downplaying, in its own marketing materials, that owners would now pay per visit or seasonal pass fees for amenities the declaration had always guaranteed as free. For several weeks ahead of the scheduled vote, with the resort's polished marketing materials circulating widely, and a genuine minority of owners persuaded that professional resort management might actually improve amenity quality, I worried the community, having already spent considerable energy on the rental mandate and board removal fights, might simply lack the appetite for a third consecutive confrontation in the same year. What ultimately defeated the proposal was a straightforward reading Otto insisted on presenting plainly at the final community meeting before the vote. Regardless of whatever service improvements Silver Notch promised, the original 1998 declaration guaranteed free amenity access as a permanent owner right, and approving the licensing arrangement would require owners to affirmatively vote away a benefit they already owned outright, in exchange for a resort operator's promise of improved service quality that carried no binding guarantee whatsoever beyond the initial marketing pitch. Beatrix Solano, still assisting the community in a consulting capacity even after her original forensic work concluded, prepared a straightforward financial comparison showing that the proposed seasonal amenity pass pricing, extrapolated across a typical owner household's actual usage pattern, would cost most families more annually than the entire rental mandate commission overcharge Garrison's scheme had originally imposed, a comparison that reframed the vote, for most owners, from a service quality question into a simple, unambiguous question of whether to give away a right they already had for free. The amenities licensing arrangement failed to reach the required two-thirds threshold, receiving support from barely a quarter of voting owners, and under the declaration's own governance terms, a failed licensing vote of this kind cannot be reintroduced for the same amenities within 3 years, absent a documented material change in circumstances, effectively closing off Silver Notch Resort Group's conversion strategy for the foreseeable future. Otto Reinhold was elected board president in his own right at the following annual meeting, running on a platform centered specifically on restoring competitive bidding requirements for any vendor contract above $10,000, and mandatory conflict of interest disclosure for any board member with a financial relationship to a prospective vendor, reforms the ownership approved by an overwhelming margin, given everything the community had collectively learned that year. Colette's parallel complaints at the 2 other resort communities she'd flagged to the State Division also resulted in formal enforcement determinations that year, and she tells me the Rental Management Freedom Act has, since our own case became something of a known example among property managers on the mountain, been cited by owners at no fewer than 6 other ski and beach resort communities statewide, a ripple effect neither of us anticipated back when I first found the statute buried in a legislative database search that had really only been meant to answer my own, considerably smaller, question about my own single chalet. Colette Fournier's independent management business grew considerably once owners felt genuinely free to choose their own rental manager without fear of the fines Garrison's mandate had once threatened, and she now manages nearly a third of Timberline Village's rental active units, a market share she's earned, she likes to point out, entirely on service quality and a fair commission rate, rather than any board mandate forcing owners her way. The $310,000 recovery from Garrison, Priya, and Ilsa's settlement funded a genuine amenity improvement program the following year. New pool equipment, a renovated gear storage room, an expanded shuttle schedule, delivered as a straightforward capital improvement to a benefit owners already possessed for free, rather than as leverage for converting it into a paid resort product. I still use Colette to manage my own unit, at her original 18% commission, and I keep, framed in my own chalet's entryway, somewhat as a joke among visiting friends, a printed copy of the Rental Management Freedom Act's key provision, the one Garrison's board apparently hoped none of us would ever bother reading closely enough to invoke against them. I never set out to remove a board or fight a ski resort's own corporate parent. I just wanted to keep using a property manager I trusted at a fair price, and it turned out the state had already given me exactly the legal tool I needed to do that, sitting quietly on the books for 6 months, before anybody at Timberline Village ever thought to actually read it. Would you have simply switched to your HOA's mandated vendor, rather than research whether that mandate was even legal in the first place? Or is it worth checking what your own state's laws actually say, before assuming your board's rules are the last word? Let me know in the comments below. A realtor told restricted homeowners their affordability covenant had basically expired, so he could flip their homes at market price. So we unwound every sale and killed the ordinance that would have made it legal. Cedar Commons is a 42-unit community land trust neighborhood, built specifically to keep homeownership affordable for working families for 30 years, under a recorded deed covenant that caps resale prices well below market value in exchange for the below-market price families paid to buy in. A real estate agent spent 2 years quietly convincing restricted owners their covenant had basically expired, helping them sell at full market price to unqualified buyers, and pocketing enormous commissions along the way. It took me a records request, a forensic compliance audit, and a city council hearing to learn he wasn't acting alone, and that the ordinance he was hoping to get passed would have made what he'd already done to a dozen families completely legal for everyone else too. My name's Yolanda Briggs. I'm 55, work as a housing counselor for a regional nonprofit, and I've served as a volunteer board member for the Cedar Commons Community Land Trust for 11 years. Since not long after my own family bought our home there, under the same program I now help oversee for other families. Community land trusts work through an arrangement designed specifically to keep homeownership genuinely affordable across generations, rather than just for a single lucky buyer. The trust retains ownership of the underlying land permanently, leasing it to homeowners under a long-term ground lease, while the homeowner owns the house itself outright, purchased originally at a below-market price reflecting the land cost savings. In exchange, the homeowner's deed carries a recorded covenant, tied to the ground lease, capping the price at which they can eventually resell the home using a formula designed to preserve affordability for the next income-qualified buyer, typically limiting appreciation to a modest, formula-based percentage, rather than allowing the home to simply track the open market the way an unrestricted property would. I bought into Cedar Commons myself 11 years ago, as a single mother working 2 jobs, and I still remember sitting at the closing table, genuinely disbelieving that a family income like mine could actually own a home in a city where market rate prices had already pushed most working families like ours permanently into renting. That memory is part of why I volunteered for the Land Trust Board almost immediately after moving in, wanting to help extend the same opportunity to other families the way it had been extended to mine, a motivation that made everything I eventually uncovered feel less like an abstract compliance failure and more like a betrayal of something I'd personally staked my own family's stability on. Cedar Commons, 42 townhomes built 15 years ago under our city's inclusionary housing ordinance, operates under exactly this model, with covenants recorded to run for 30 years, from each unit's original sale date, monitored and enforced by the Land Trust's small staff, led for most of the community's existence by an executive director named Trevor Aldenberg, a position I'd always considered, without much reason to think otherwise, a straightforwardly administrative role, rather than one carrying much opportunity for the kind of exploitation that eventually surfaced. I first noticed something wrong while helping my own daughter, Camille, apply for one of Cedar Commons' units that had recently come up for resale, a 3-bedroom townhome that had belonged to a family named the Delacroix Osei household for 9 years. When I pulled the resale paperwork to help Camille understand the formula price she'd be paying, I found the unit had already sold 2 months earlier, not to an income-qualified buyer through the trust's standard resale process, but through a conventional open market sale to a buyer with no income qualification documentation on file at all, at a price nearly $190,000 above what our own recorded resale formula should have capped it at. I called Trevor Aldenberg's office to ask how a covenant-restricted unit had sold on the open market without triggering the trust's mandatory right of first refusal and formula price requirement, and the answer I received, from a junior staff member rather than Trevor himself, was that Mr. Aldenberg approved a covenant release for that unit based on updated program guidance, language vague enough that I asked to see the actual documentation supporting that release. What I eventually obtained, after a formal records request under the Land Trust's own bylaws requiring board member access to compliance files, was a one-page memo signed by Trevor stating that the unit's covenant had been released because the original 30-year affordability term is scheduled for early sunset review under anticipated ordinance revisions. A justification that, as far as I knew from 11 years serving on the very board that would have had to approve any such policy change, had never actually been adopted or even formally discussed by the board at all. I called the Delacroix-Osei family directly, reaching the son who'd handled the sale on his elderly mother's behalf, and he explained that a real estate agent named Dario Kessler had approached the family the previous year, explaining that Cedar Commons' affordability covenants were basically expiring soon under a new city policy, and that the family could either sell now at a grandfathered market rate. Dario said he could arrange through his contacts at the Land Trust, or wait and potentially lose that flexibility once the formal policy took effect. Dario's commission on that sale, based on the closing disclosure the family shared with me once they understood what had actually happened, came to just over $22,000, calculated on the full unrestricted market price, rather than the far smaller formula price the covenant should have limited the transaction to. I called Dario Kessler directly, identifying myself as a Cedar Commons board member, and asked him to explain the basis for telling the Delacroix-Osei family their covenant was expiring under a policy that, to my direct knowledge as a sitting board member, had never been adopted. His response was the moment I understood exactly what kind of operation I was actually dealing with. Ms. Briggs, I work with several affordability-restricted communities across the city, and there's genuinely been discussion at the city level about sunset provisions for these older covenants. I gave the family my honest professional read of where things are headed. If your land trust's own executive director signed off on the release, that's really between you and him, not something I engineered myself. He said it with the practiced confidence of someone who'd clearly prepared for exactly this kind of pushback well in advance, carefully positioning Trevor's signature as the operative approval rather than his own role in generating the pressure that had led to it. I didn't have the resources for an immediate lawsuit on my own, so instead of hiring an attorney first, I brought the entire situation to the full Cedar Commons board, most of whose members, like me, had never had reason to question Trevor's routine administrative decisions closely before. The board authorized a formal records review of every resale transaction processed during Trevor's tenure, a review I volunteered to lead given my own professional background in affordable housing compliance work. That review, completed over 6 weeks of going through every resale file the trust had processed over the preceding 4 years, found 11 additional units, beyond the Delacroix-Osei sale, that had been released from their covenants under similar, anticipated ordinance revision justifications, all processed by Trevor personally, rather than through the board approval, our own governing documents required for any covenant modification, and all involving Dario Kessler as the listing or selling agent, earning commissions collectively totaling just over $240,000 across the 12 improperly released sales. I called each of the 12 affected families myself before the litigation began, a series of conversations I found considerably harder than the records research had been, since most of them had genuinely believed, based entirely on Dario's confident assurances, that they were simply claiming equity they were rightfully owed after years of below-market ownership, rather than participating in anything improper. A retired bus driver named Willis Okonkwo Bramley, one of the original sellers, told me he'd used part of his sale proceeds to help his granddaughter with college tuition, and the idea that the trust might now claw back part of that money weighed on me heavily enough that I pushed our board attorney specifically to structure the eventual settlement around protecting sellers like Willis from any personal repayment obligation, focusing recovery instead on unwinding the improper resale terms against the properties, and, ultimately, against Dario and Trevor directly. Our board attorney, once retained, explained that each of these 12 sales represented a covenant violation that, under the recorded deed restriction and ground lease terms, remained enforceable against the current title holders, regardless of whether those buyers had purchased in good faith or not. Since a recorded covenant runs with the land and binds subsequent owners on notice of its existence, notice that, in this case, existed plainly in the public land records regardless of whatever informal assurances Dario Kessler had privately offered sellers about its supposed expiration. She filed formal notices of lis pendens against all 12 properties, alerting any future buyer, lender, or title company that litigation affecting each title was pending, while the board simultaneously pursued a formal action seeking to void each improper sale and restore the trust's proper resale formula and income qualification requirements. That litigation, running over the following year against 12 separate sets of current owners, several of whom had purchased in apparent good faith without any knowledge of Dario's misrepresentations to the original sellers, resolved through a structured settlement our board attorney negotiated. Current owners who could demonstrate genuine good faith purchase without knowledge of the covenant violation were offered the option either to remain in their homes by paying the difference between what they'd paid and the trust's covenant-compliant formula price, effectively converting their purchase into a proper, income-qualified restricted sale going forward, or to sell back to the trust at the price they'd originally paid, allowing the trust to then resell the unit properly to an income-qualified buyer at the correct formula price. 9 of the 12 owners chose the first option, 6 of them qualifying for the program's income limits regardless, and simply needing to formalize their status, while 3 sold back to the trust, which resold those units within the following year to newly qualified families from the trust's own waiting list. I thought, once that settlement closed and every covenant was formally restored, that Cedar Commons had successfully corrected a serious but contained compliance failure. I was wrong about it being contained, in a way that revealed Dario Kessler had never been working independently in the first place. Our board attorney, reviewing Dario Kessler's real estate licensing records as part of the broader litigation, discovered that he held an exclusive referral arrangement with a real estate investment firm called Anchor Point Capital, which, according to public property records she compiled across the city's several other community land trust and inclusionary housing developments, had acquired or attempted to acquire similarly de-restricted units at no fewer than 4 other affordable housing communities over the preceding 3 years, using agents and justifications strikingly similar to what Dario had used at Cedar Commons. Confronting Trevor Aldenberg directly about the pattern, once our internal review had documented all 12 improper releases, produced a confession considerably more direct than I'd expected once he understood how thoroughly the board had already reconstructed the timeline. Trevor admitted that Dario Kessler had been providing him with cash payments, disguised as consulting fees, for unspecified market research Trevor could never actually produce documentation for, totaling roughly $8,000 per released covenant, payments that had begun, based on Trevor's own admission, after Dario first approached him directly, rather than the other way around, framing the arrangement, in Trevor's own recollection, as simply helping a few long-tenured families finally realize the equity they deserved after years of below-market ownership. A rationalization that, however Trevor had convinced himself of its fairness, ignored entirely the fact that it was Dario and Anchor Point Capital's downstream buyers capturing the actual windfall, not the families themselves, who'd sold under a materially false understanding of their own covenant's actual, unchanged legal status. The board removed Trevor immediately and reported the matter to the state's Housing Finance Agency, which maintains regulatory oversight of community land trusts receiving state affordable housing program funding, a category that included Cedar Commons, given the state financing that had helped fund the original development. The agency opened its own independent forensic compliance audit, considerably more comprehensive than our own board-led review had been able to conduct on volunteer time and limited budget. examining not just the 12 already identified releases, but every transaction across the trust's full 15-year history. Trevor's attorney, once the state agency's audit was underway, attempted to characterize his conduct as a series of individually defensible judgment calls rather than a coordinated bribery scheme, arguing that each release decision, however irregular procedurally, had been made with a genuine if mistaken belief that helping restricted families access their home equity served a legitimate purpose the land trust's broader mission could accommodate. That characterization, for several tense weeks while the state agency's own investigators worked through Trevor's financial records, threatened to reduce what our board considered a clear-cut corruption case into something closer to an ambiguous governance dispute that might result in nothing more than Trevor's quiet resignation rather than any real accountability, or, more importantly, any systemic fix preventing a repeat by whoever came next. The state agency's forensic accountants ultimately traced the consulting fee payments directly to a bank account Dario Kessler controlled, with wire transfer memos in at least 4 instances explicitly referencing specific Cedar Commons unit addresses by name, documentation that eliminated any plausible reading of the payments as legitimate, unrelated consulting income and confirmed the arrangement as a straightforward bribery scheme, tied unit by unit to each improper covenant release. The agency referred the matter to the State Attorney General's office for potential criminal prosecution, and separately required Cedar Commons to implement a new, board-approved covenant release policy requiring any future release to be approved by unanimous board vote with independent legal review, a considerably stricter standard than the informal, single-signature process Trevor had been able to exploit throughout his tenure. That resolution, once finalized, felt like a genuinely thorough accounting of exactly how Dario Kessler and Trevor Aldenberg's scheme had operated at Cedar Commons specifically. I was wrong about it being the full extent of what Anchor Point Capital had actually been building toward across the city, in a way that revealed our own community's exploitation had been part of a considerably larger, coordinated push. Our board attorney, tracking Anchor Point Capital's broader activity once the state investigation into Trevor and Dario closed, discovered the firm had retained a lobbying consultant who'd been meeting regularly with several city council members over the preceding year, advocating for an ordinance amendment that would reduce the standard affordability covenant term citywide from 30 years to 15 years for all existing inclusionary housing developments, framed publicly as a measure to restore homeowner equity mobility for long-tenured restricted covenant families, language that echoed, uncomfortably closely, the exact justification Trevor Aldenberg had used to rationalize his own scheme to himself. Mapped against Anchor Point Capital's documented acquisition pattern across multiple communities, the ordinance amendment's actual effect became clear. It would have retroactively legalized, for every affordability-restricted community across the city, including the developments where Anchor Point had already improperly acquired de-restricted units. Exactly the kind of premature covenant termination Dario Kessler had achieved fraudulently at Cedar Commons, converting what our own litigation had successfully unwound as illegal transactions into a citywide, perfectly legal windfall for any investor positioned to acquire similarly restricted units before the ordinance's effective date. The proposed ordinance amendment was scheduled for a city council committee hearing the following spring, and I spent the intervening months drawing directly on both my professional housing counseling background and Cedar Commons' own recent, hard-won experience, helping organize a coalition of residents from every affordability-restricted community across the city that Anchor Point Capital's activity had touched, eventually representing over 300 households under a banner we called the Citywide Covenant Preservation Coalition. Willis Okonkwo Bramley, once he understood the settlement structure would never require him to personally repay any of the money he'd already spent on his granddaughter's tuition, agreed to testify himself at the eventual council hearing, telling the committee plainly that he'd been an unwitting participant in a scheme rather than any kind of willing accomplice. Testimony I believe carried more weight with several council members than my own more technical presentation managed on its own. I testified before the council committee myself, walking through Cedar Commons' own documented experience in detail, the Delacroix Osei family's false understanding of their covenant status, Trevor Aldenberg's bribery scheme, and the 12 improperly released units our board had spent over a year and considerable legal expense unwinding, framing the proposed ordinance not as an abstract policy question, but as the exact scheme our community had already fought off, now seeking legislative cover to operate everywhere else, without the inconvenience of needing to bribe anyone at all. A housing policy researcher the coalition retained presented a citywide displacement impact analysis, showing that a 15-year covenant sunset would, based on current market appreciation trends across the city's inclusionary developments, ultimately convert an estimated 60% of the city's entire affordable homeownership stock to market-rate ownership within a single decade of the amendment's passage, effectively unwinding 2 decades of the city's own affordable housing policy investment through a single ordinance change most residents would likely never fully understand until their own covenant quietly disappeared. Anchor Point Capital's lobbying consultant presented the council committee with testimonials from several restricted homeowners, genuinely sympathetic longtime residents, who spoke earnestly about wanting greater flexibility to access their home equity for retirement, medical expenses, or family needs. Testimony that, for several uncomfortable weeks ahead of the committee's scheduled vote, complicated the coalition's messaging considerably, since our own position risked sounding, if not carefully framed, like an argument against homeowner flexibility rather than what it actually was, an argument against a policy that would functionally transfer the accumulated public affordability investment in these homes into private developers' pockets, rather than preserving it for the next generation of families the original program had been designed to serve. What ultimately shifted the committee's position was a modification the coalition proposed as a genuine alternative rather than simple opposition. A hardship equity access provision allowing restricted homeowners facing documented medical, disability, or retirement hardship to access a defined, limited portion of their formula-capped equity through a low-interest loan program administered by the city's housing department, without terminating the underlying covenant or opening the unit to unrestricted resale. Addressing the genuine flexibility concern Anchor Point's testimonials had raised, without gutting the affordability protection itself for the community's future generations. The committee ultimately rejected Anchor Point Capital's proposed 15-year sunset ordinance entirely, adopting instead the coalition's hardship equity access alternative, a resolution that the city's own housing department director characterized, in comments to the local press covering the vote, as exactly the kind of community-driven policy correction that comes from people who've actually lived through what a poorly designed alternative would have allowed to happen to them. Anchor Point Capital's acquisitions at the 4 other communities its earlier activity had touched became the subject of separate litigation, several drawing directly on the legal theory and settlement structure our own Cedar Commons board attorney had developed, ultimately unwinding a majority of those improperly acquired units as well, restoring them to proper covenant compliance, and returning them to income-qualified families over the following 2 years. Trevor Aldenberg pled guilty to a reduced bribery charge under a plea agreement requiring restitution and permanent disqualification from serving in any nonprofit housing administration role in the state, a resolution our board considered appropriately serious, without the extended uncertainty a full trial would have required. Dario Kessler's real estate license was permanently revoked following a state licensing board proceeding that drew directly on the same wire transfer documentation the Housing Finance Agency's forensic audit had developed. Willis Okonkwo Bramley still lives 2 doors down from where he sold his own former unit, having moved into a smaller Cedar Commons townhome once the settlement gave him that option, and he tells me, whenever I run into him at the community mailboxes, that testifying at that hearing was the first time in 71 years anybody in city government asked me what I actually thought about something that affected my own life directly, a comment that stuck with me longer than almost anything else from that entire year. Camille, my daughter, ultimately did purchase a Cedar Commons unit the following year, one of the 3 properties the trust reclaimed and resold through its properly restored formula process, and she jokes now that she's the only homebuyer she knows, whose mother's due diligence on a single resale listing accidentally uncovered a citywide housing fraud scheme before anyone had even signed a purchase agreement. I still chair Cedar Commons Compliance Committee, a role the board formally created following everything that happened, meeting monthly to review every single resale transaction line by line, rather than trusting any single administrator's signature the way our governing documents once implicitly allowed. A level of ongoing vigilance I hope none of the next families who eventually inherit this responsibility from me will ever have quite as urgent a reason to maintain as we did. I never set out to unwind a dozen home sales or stop a city ordinance. I just wanted to understand why my own daughter's future home had already sold for $200,000 more than the formula on the deed allowed. And it turned out that question was enough to protect not just Cedar Commons, but every family this city's affordable housing program was ever actually built to serve. Would you know how to check whether your own community's affordability covenant is actually being enforced the way it's written on the deed? Or is it worth asking the question before somebody convinces you it's already quietly expired? Let me know in the comments below. This video is a dramatized storytelling narrative based on real-life themes and community land trust, affordable housing covenant, and municipal housing policy regulations. Names, characters, and specific locations are fictional or have been changed for privacy. Visuals are generated using AI tools for illustrative purposes only. This content is for entertainment purposes and does not constitute legal advice.